So in a landlord-tenant situation where a contractor is building out somebody's tenant space, there's a lot of risk to the landlord for that. And that's because of the laws that we have in Nevada. A contractor who is not paid on a project has the right to foreclose against the property, not just the lease space, but the whole property. I had a case several years ago. I was representing a general contractor who was building out a coffee shop in a big mall. And that coffee shop got going, it went under, and it never paid the contractor. I represented the contractor. We didn't put a lien on that little coffee shop. You get to lien the whole mall. And that's what we did. And we got within a month or two of foreclosing on the mall. They would have gone and auctioned off the mall to somebody on the courthouse steps if that had kept going. But the mall finally, even though they had nothing to do with this project, and actually ended up having to tear it down after the guy left at their expense, they had to pay the contractor for the work because they didn't use construction control. With 3-Lock the landlord would require the tenant to use 3-Lock in its lease. And then the tenant has to hire us, and it puts the money for its construction project into our escrow account before work starts. Once they've done that, a document gets recorded that that's occurred. If a builder doesn't get paid, they have their lien rights against my escrow account and not against the property. So the question is why doesn't everybody use 3-Lock or construction escrow as a general principle on tenant improvements? And the answer to that is not only should they use 3-Lock, but the law actually requires, it is a mandate of Nevada law, that on a tenant improvement, you have to either use a construction control company and fund it like I described, or go out and buy an expensive bond and record that. There is no other option. If you don't do that under Nevada law, the contractor can just walk off the project at any time. They can just leave.